So good afternoon to all of you. Welcome you to Veranda CA session on RTP questions on paper 4, corporate and economic laws. I have to give you a prelude to the session that the questions that we are going to discuss today are a bit lengthier, are a bit confusing, but I'll make sure that it is made simpler for you to understand. Since it encompasses a lot of critical aspects of both Companies Act and SEBI LODR, we need to be more careful in assessing the question and also writing an appropriate answer. So let's go to the first question. So I'll go with the flow of the question. In case there are any doubts, we can always interrupt in between and then get it clarified. So the first question is, the composition of the board of directors of a listed company, the wording used is listed company, as on 31/3/2017 comprised of Mr. A, a director, B, a director, C, a director, D, a director, Mrs. E, an independent women director, Mr. F, an independent director, Mr. G, an independent director. So as such, there is a combination of four non-independent directors and 3 independent directors, of which there is 1 women independent director. You are required to examine with reference to the provisions of the law of the vacation of office of Mr. D and Mrs. E and discuss the course of action that can be taken by the company. Here, the question is vacation of office, which happens after the director is inducted to the board. So he currently serves on the board and his office is going to come to an end. Therefore, he's going to vacate the office, of which the vacation of office of one of the women director is also involved. So let's see what are the provisions that is to be complied with. Then we'll come to the next question. The provisions relating to appointment of a women director and independent directors are given in section 149. It says, the second proviso says that such class of companies may have, shall have at least 1 women director, and rule 3 of the appointment and qualification of directors rule provides the list of companies on which at least 1 shall be a women director. Every listed company, irrespective of size, every other public company having a paid up capital of 100 crore or more, or turnover of 300 crores or more, shall mandatorily have a women director. It never said that mandatorily you must have a women independent director. It says mandatorily shall have a women director on the board. For listed company, it shall be a women independent director, whereas in respect of other public company, it becomes a women director. So it's very clear that this is a listed company of which one of the women director is going to vacate the office, and therefore the question is that what will happen if the women director vacates the office? The law provides that in case there is a vacancy arising out of resignation or vacation of office of a women director, it shall be filled. That is, the vacancy shall be filled not later than immediately next board meeting or 3 months, whichever is later. See, today the process of appointment of independent director is a very cumbersome process, and to find any director is a cumbersome process. It has to go through the nomination remuneration committee. It has to undergo the qualification procedures, the criteria, and all that. So the act gives you time for about 3 months to fill in the vacancy. So you should either fill it at the next board meeting if you find one, or within 3 months from the date of vacation of office, you must have a women director. In case the company is listed under the provisions of it is required to have at least one women director. So in respect of women director, we shall be very clear that it has to be, if there is a vacation of office or a resignation, you will have to fill else 3 months from the date of whichever is later. Any doubts in this? Any doubts? If there are no doubts, just ping me a chat message that there are no doubts so that we can take up the next question. Yeah. So we'll go to the next one. The provisions of section 149(4) also provides for one more thing. That is, the composition of the board of directors. There are 2 parts. One is Every listed company shall have at least 1/3 of the total number of directors as independent director. Now, who is an independent director? Any director who qualifies by way of a declaration of independence, neither he nor his relatives hold any security beyond a threshold, or is not having any pecuniary transactions with the company in the preceding 2 years, either himself or through his relatives, and takes only remuneration. It does not hold any security within the company. So there shall be at least 1/3 of the directors as independent directors as per the provisions of the Companies Act 2013. Whereas if you take in respect of a listed company, it may undergo a change, because under the SEBI LODR, if the chairman of the company happens to be a promoter or falls within the promoter group, then 1/2 shall be independent directors. Otherwise, it is 1/3 shall be independent directors. Composition as on 31st March, it consisted of 7 directors, of which 4 were non-independent and 3 were independent. Later, Mrs. Director and let's forget that there were 4 and 3. So, as per law, 1/3 of 7. What is 1/3 of 7? Any idea? 1/3 of 7. Can I have your answers, please?
3.
You must have 3. What is 1/3 of 7? Just calculator would do. What is 1/3 of 7? 2.33. So 2.33 is always rounded off to the nearest number, which is 2. And therefore, as on that date, the composition is correct. However, there are 2 directors who are going to vacate the office, and therefore the composition is in violation of the law. Therefore, they will have to induct immediately another independent director. And if it happens to be women, then it is all the more safer. So in this case, it shall have at least 1 women independent director on the board and 1/3 of the independent directors. However, on 15/4, the total number of directors left were 5, and therefore the intermittent vacancy should be filled in on or before the next board meeting or 3 months, whichever is later. It never says that you'll have to appoint immediately. It gives you the time. But if you don't appoint within that time, then it becomes a violation. Got it? So as on 31/3, the composition is perfect. But because of the vacation of office of 2 directors, there's a vacancy that's being caused. Therefore, fill in the vacancy on or before the next board meeting or within 3 months from the date of the vacation of office, whichever is later, but comply with the law. So this is the first question. Now we'll go to question number 2 and then go to the next part. Anybody doubtful of this question number A? If there are any doubts, we'll clarify it. If there are no doubts, then we'll move forward. No doubts? Yeah. So we'll go to the next question. Question number 1, point number B. Discuss the legal position in the given situation relating to Companies Act. Mr. Arthav, a director, resigns after giving due notice to the company, and he forwards a copy of the resignation letter in e-form DIR 11 to the ROC within the prescribed time. Besides, the company fails to intimate about the resignation of Mr. Arthav to ROC. So the director has resigned. It is the duty of the company to file form DIR 12. DIR 12. The director may file. See, it is not mandatory now that the director also has to file. Earlier, it was mandatory. Now it is not so. DIR 11 may be forwarded by the director directly to the Register of Companies. However, in this case, the director has sent e-form DIR 11. However, the company has failed to intimate the resignation of Arthav to ROC in DIR 12. The next question is, okay, we'll come to question number 1A and then go to question number 1B. Let's see the question and then go and answer it together. The Board of Superwoods Limited decides to appoint Mr. Ramkant as a nominee director upon the request of a bank which has extended long-term financial assistance. The articles does not confer that power Also, there is no formal agreement between the company for such nomination. Now, the question is, what is that legal provision? So let's first answer 1BA and then go to 1BC. So in the case of resignation of a director can resign the office by giving notice to the company. That is, the director will forward his resignation letter. The board shall acknowledge the resignation letter and take note of the same. It doesn't require any approval. Please note, the resignation of director doesn't require the approval of the board. As soon as it comes, it may be placed at the board meeting. It doesn't mean that it has to be approved by the board. It can be placed and taken note of. Taken note of is different from approval. Take a note is just taking note. There's no action that is required. There's no acceptance that is required. Suppose I'm a director and I'm saying that I'm going to get resigned from the company effective 23rd of January. My resignation takes effect from 23rd of January. No matter whether there's a board, it's going to consider it or not is not a question. This is applicable only to non-executive directors. And I myself can go file a resignation letter with the Registrar of Companies in form E-Form DAR 11. Therefore, he forwarding it to the ROC is perfectly valid if it is done within 30 days. However, in the question, it says that the company has failed to inform the registrar. So therefore, what is the duty of the director? It is the duty of the director to file E-Form DAR 11 with the registrar so that his name is removed from the list of directors. However, the company will also have to file DAR 12 by paying additional fees. In this case, only the director has filed, the company has failed to file. Therefore, the company and every officer in default is liable to pay penalty not exceeding 18 times. The wording used is not exceeding because as per a recent amendment, the number of times with which the penalty is increasing has undergone a different level of change. So maximum penalty is 18 times the normal fee payable. So in this case, Arthav has filed it with the registrar within 30 days. Therefore, he is compliant. However, the company continues to remain non-compliant. Any doubts in this? Any doubts? No doubts. So we'll go to the next point. Next point that talks about appointment of a nominee director. Now, who is a nominee director? A nominee director is a person who is nominated by another director or a bank or a financial institution to represent its interest. However, if a director nominates another director, he becomes an alternate director. Whereas if a financial institution nominates another person or a bank nominating a person, it means he is called a nominee director. As per section 161, it says, subject to articles of association, the company may appoint a person as director nominated by any institution or by the state government. If the articles doesn't provide, articles is the internal charter. If the article doesn't provide, you cannot appoint any person as a nominee director. So what is to be done? You need to amend the articles, get it approved by the registrar, members and then the registrar, and then induct him. If there are no, even though there is a formal agreement, whether there is a formal agreement or not, if the articles doesn't provide for it, you cannot appoint a nominee director. That's the law. In this case, the articles also does not provide. Second, there is no contract between the bank and the company that there will be a nominee director, and therefore the board cannot appoint Mr. Ramakant as a nominee director because it is not provided by the articles nor by an agreement between the bank and the financial institution and the company, and therefore such an appointment is not valid. Question. We'll go to the next question. The promoters of Frontline Limited, a listed public company, proposes to have the strength of board of directors as 11. They also propose to make the managing director and whole-time directors not liable to retire by rotation. Advise the company on the following matters. What is the maximum number of persons who can be appointed as director not liable to retire by rotation? How many remaining directors will have to retire by rotation at the AGM? So let's understand two things. The wording used is persons liable to retire by rotation and the actual rotation are totally different. When I say person liable to retire by rotation, it means that I am a person who is identified to be retiring by rotation, but I need not retire. I'm only liable. But who will actually retire is a different question altogether, which we will see now. And it also asks, can the board of directors increase the strength of the company to 18 from 11 by appointing additional director by passing a single resolution? So let's go step by step. We've seen the 3 questions. We'll go step by step and answer everything. According to 152, unless the articles provide for retirement of all the directors at every annual general meeting, not less than 2/3 of the directors as are liable to retire by rotation, who holds the longest period of office is liable to retire by rotation. What it says that, assuming I have 10 directors in a listed company, there will be executive, non-executive and independent directors. Independent directors are not liable to retire by rotation under law, so they are excluded. Even though your articles may provide all the directors will have to retire, independent directors are outside the purview. So independent directors should not be taken. Assuming there are 10 directors, of which 5 are independent directors, the balance 5 will be called a director liable to retire by rotation. Here, it can include non-executive, non-independent director and also an executive director. A whole-time director can also liable to be retired by rotation. Similarly, a non-executive director and a non-being independent director is also liable to retire by rotation. Therefore, under law, exclude independent directors for the purposes of this section. Of the balance, 2/3 are liable to retire by rotation. Normally, of 5 into 2 by 3, which is 10 by 3, which is 3.33. So 3 directors are liable to retire by rotation. Please note, they're only liable, they don't retire. They are liable to retire by rotation. Of the 3, 1/3 will retire. That is, of the 3 who has the longest office, 1/3, that is 3 la 1/3, which is 1% will retire. He may get reappointed subject to approval of the shareholders. That is what law is. Please understand, of the whole directors, independent directors are excluded. Of the remaining directors, 2/3 are liable to retire by rotation, of which 1/3 will retire. That is the law. Any doubts in this? Any doubts till this? Any doubts? Because the subsequent questions are answers are going to be dependent on your understanding now. If you have anything, please let me know. So it says clear. So I'm proceeding. Oh, Rajesh Kumar, you said you were not able to understand. There are 10 directors today in a company, of which 5 are independent directors and 5 are non-independent directors. Can you note it down? 5 are independent directors and 5 are non-independent directors. Now, these 5 independent directors are not liable to retire by rotation. Therefore, the balance 5 are liable to retire by rotation. Now, of the 5, 2/3 are liable. Mandatorily, 2/3 are liable. So, of the 5, there will be 3.33 directors rounded off to 3 who will be identified as to be retiring. That is 3 directors. Now, how will you compute these 3 directors? Every director who has the longest tenure will retire first. He is there for 10 years, so he will retire first. 9 years director will retire next. So these 3 will be identified as director liable to retire by rotation. Of the 3 directors who are liable, 1/3 will retire. So 1/3 is of the 3, 1/3, which is 3 into 1 by 3, which is 1. Which director will retire at this annual general meeting? However, he can be reappointed. Any doubts till this? Rajesh, are you able to understand now? Yeah. Now, in this question, there are 11 directors. So of 11, what is 2 by 3? 7.3 or 8. Here, we are not making any distinction between independent directors because it is not explicitly available in the question. Therefore, we are assuming all directors are liable to retire by rotation. Therefore, of 11 into 2 by 3 is 7.3 or 8. Normally, it is rounded off to the nearest down, but the articles may provide for a higher one. So the maximum number who can be appointed as director not liable to rotation is 3. So therefore, the number of directors who are liable to rotation by 3 is of the 8, 1/3. What is of the 8, 1/3? 8 into 1 by 3 is 2.66. Therefore, 3 directors will retire. The nearest number is 3. Therefore, 3 directors will retire. Any doubts till this? There are 11 directors, of which all of them are liable to retire by rotation. So of 11, there will be 8 who will be liable. Of 8, 1/3, which is 3 directors. Okay, got it? Any doubts till that? Can we move over to the next question? Okay. So according to section 160 of the Act, a person who is not a retiring director shall be eligible for appointment of an office at the general meeting by giving not less than 14 days. This is a normal procedure where a person who is not a retiring director because normally a director is appointed as an additional director and holds office till the ensuing annual general meeting, after which only he becomes a director liable to retire by rotation. Therefore, any person who is not a retiring director can apply to the company that he intends to become a director by giving 14 days notice, and his directorship must be proposed and seconded by another person. In the instant case, one nomination was rejected by directors as it was received after sending the AGM notice, and that too after the working hours, and therefore the fact that it was received after the AGM and after the working hours is perfectly valid, and the nomination need not be considered. And if the company wants to have more than 15 directors, it has to do it by way of passing a special resolution. In the instant case, they would like to increase the number of directors from 11 to 18, not 11 to 15. From 11 to 15, there's no problem. You can go in the normal road. But if you're going to increase it from 11 to 18, which is in excess of 15, then you can do it. That is, the board can do it, but can do it only after passing a special resolution to this effect and then appoint directors. But all the directors will have to be appointed individually. A single resolution cannot be made. That is, in one resolution you can't appoint all the directors. For each and every director there must be a separate resolution, and for each resolution there must be a proposer and a seconder, and that has to be voted. You cannot appoint every director in a single resolution. You cannot put a tabular column and appoint all of them. No, you have to appoint every single director individually, because under the Companies Act, every director shall be appointed individually. Any doubts? Any doubts? Yeah, so somebody has the question: for increasing the number of directors above 15, articles need to be amended. So the question here is, what is the article provide for? Article cannot directly provide for 18. Articles can provide, say that it can be as per the Companies Act. So you must go to the articles and see if there is any restriction to that effect. If there is a restriction, you need to amend the articles and then change it. If the article says that the maximum directorship shall be as per the company law, as per the prescriptions of company law, then there's no problem. You don't have to amend the articles. If the article says that you cannot exceed 15, then in that case you need to amend the articles and then get the special resolution part to the next question. The board of directors of Universal Limited, which is a multinational, comprised of directors who were in India as well as foreign nationals. Mr. X, who is a director on the board, is very often on business tour abroad. He approached you, being a legal expert, to know the regulatory provisions relating to appointment of alternate directors. So the question is very simple. Please state the provisions of Companies Act relating to appointment of an alternate director. The question that is subsequently coming up is number of directors for which a person can be appointed, that is as an alternate director. Whether an alternate director's term of office be indefinite, can the executive or a managing director or a whole-time director appoint alternate directors? So let's go to question one by one. The board of directors can appoint an alternate director provided the articles provides for, or there is a resolution passed at a meeting to appoint a person as an alternate director. But the alternate director has to act according to the directions of the original director, and to act as an alternate director during his absence for a period of not less than 3 months from India. So you can go frequently abroad. That doesn't mean that you can appoint an alternate. Suppose you go out of India and you are here in India within the next 2 months. You cannot appoint an alternate director. Therefore, according to section 165, no person shall hold office as a director including in more than 20 companies at the same time. However, the maximum number of public companies cannot exceed 10. So he can be an alternate directorships can be only to the extent of 20 companies, which includes both private and public. However, the maximum number of public company, it is restricted to 10. Hence, in the instant case, a person can be appointed as an alternate director for only one director in the same company, but maximum of 20 different companies. So a person cannot hold an alternate directorship post for more than one director in the same company. Any doubts? Any doubts? So the first question is clear, that a person can hold office as an alternate director only in respect of one person and not more than one. And the next question is, can he hold office for a longer time? No. The Act very clearly says that the alternate director shall not hold office for a period longer than the office which the original person would have naturally held. That is, assuming my directorship as, I'm the original director and Nitesh is an addition, is my alternate. Swami's directorship is valid only till 30th January. Nikesh also can hold alternate directorship only till 30th January and cannot hold office beyond that. As soon as I return from India, this alternate directorships ceases to exist. It cannot go beyond the terms of the original director's tenure in the instant case. Oh, it's coming up again. Any doubts in this? Any doubts? Yeah. It also say, the next question is, can there be an alternate director for executive, whole-time or managing director? Please note, alternate director is only for non-executive positions. Executive position or a whole-time director or a managing director cannot appoint a nominee. That's the law. Go to the next question. Examine the provisions of the Act relating to board meeting. The chairman of Greenhouse convened a board meeting with 2 weeks notice and served on all the directors. 2 of the independent directors on the board objected on the grounds that no proper agenda for the meeting was circulated. Purple Florence Limited proposes to hold its board meeting at short notice through video conferencing. So the question now is, what are the provisions relating to notice of meeting and what are the contents, and what is it that if there is going to be a shorter term notice? According to section 173, board meeting can be called by the company secretary or by director by giving not less than 7 days notice. There's no clear notice. By giving 7 days notice. Here, the wording used is notice. It doesn't talk about agenda. Agenda is different. Notice is different. Notice is given well in advance. Agenda is circulated subsequently. In this case, the independent directors say that the meeting is not valid because agenda was not circulated. No. It is enough if I circulate a notice at least 7 days before the meeting, and agenda can be circulated at a later date. Here, according to the question, 2 independent directors have objected that no proper agenda was circulated. Please note that circulation of agenda and notice have no relevance. Notice and agenda can be separate. The Companies Act does not specifically provide. However, secretarial practice says that notice may be accompanied with the agenda. That's only a practice that's not mandated under the law. Therefore, the contention of independent director that the meeting cannot happen doesn't stand to any reason. Notice is to be given 7 days in advance. Here they've given 2 weeks in advance, which is perfectly valid. It is given by a director, which is perfectly valid. There is no law that says that the agenda should be circulated, along with the notice, and therefore the independent directors cannot object on the grounds that agenda has not been circulated. Any doubts in this? Any doubts? We'll go to the next question. The directors can participate in the meeting either in person or through audiovisual means, and subsequently due to COVID, every meeting can be held by video conferencing. The central government, though, has prescribed that there are certain things which cannot be done by video conferencing. Given the COVID situation, everything can be, the entire rule has been omitted where a meeting can be held through video conferencing. However, it has to be recorded, and there are certain protocols that has to be followed. Therefore, a meeting can be called at a shorter notice and can be held through video conferencing. However, if the meeting is called at a shorter notice, the meeting must be attended by at least one independent director who shall be present at the meeting. If the independent director is not present at the meeting, such decision should be circulated and it shall be ratified, and it will be final only if it is ratified by another independent director. That is, less than 7 days also you can call a notice due to urgency, no bar. However, the meeting shall have at least one independent director. If you are not able to have one independent director, you get it ratified from him at a later point in time and becomes valid only if it is ratified and not before. That's what. Atlantic Garments is engaged in the business of manufacturing garment for all seasons. The company have in all 14 directors. The first meeting was held on 15th February. Therefore, subsequent meetings were held on 29th February, 25th February, 30th August, and 25th December. In these meetings, full strength was present, except that in the meeting of 25th March, only 4 directors were present. Decide whether the board meeting is valid in compliance with the requirements of the law. What shall be the date of the meeting in case the meeting could not be held due to quorum? So the quorum for the board meeting, unlike the general meeting, is in the general meeting 5 members personally present for public and 2 members personally present would form the quorum. However, in the board meeting, it is 1/3 of the total directors or 2 directors, whichever is higher is what is mentioned. And video conferencing will also be taken as a valid quorum unless it could not be recorded, then that will not be counted as quorum. Audio visual means if it is recorded will form part of the quorum. So therefore, of the 14, you need at least 1/3. What is 14 by 3? What is 14 by 3? Boss, what is 14 by 3? 4.66. So when it comes to 4.66, the nearest rounding off is 5. In this case, where in one of the meetings, there are only 4 directors who were present. So does the meeting constitute a valid quorum? In that case, no. Therefore, the meeting shall stand adjourned. The wording used is stand, which means it gets automatically adjourned to the next week, the same succeeding day, which is not a national holiday. However, it shall be held at the same place and time. So in this meeting of 25th March 2020, only 4 people were present, and therefore there is no quorum that was present, and the meeting shall have to be adjourned to the next week, same day, provided that's not a national holiday. So therefore, that one particular meeting alone will not be a valid quorum. So the meeting was not valid as the quorum was present. In this case, the adjourned meeting was to be held on 1st April 2020, which is exactly the next 1 week from the date of the previous meeting.